January 10th, 2017, 18th meeting of the City of Lake Forest Plan Commission. I am Michael Lay, Chairman of the Commission, and at this time I would like to introduce the members of the Commission who are here this evening. To my right is Commissioner Freeman. To my far left is Commissioner Pickus, then Commissioner Ruggles, and to my immediate left, Commissioner Kerr. And from city staff, we have Kathy Zerniak, the Director of Community Development, here as well.
Doesn't look like you have the right
Our
connection
first
right
item of business on our agenda is consideration and approval of the minutes of the December 13th, 2017 Plan Commission meeting. That was sent to us in advance of the meeting. Does anyone have any additions, deletions, typos, anything? No. Okay, seeing none, a motion to approve the minutes is in order.
now, and we're not gonna be.
So moved.
It's been moved. Is there a second?
Second.
It's been moved and seconded. All those in favor of approval of the minutes indicate by saying aye.
Aye.
Opposed, no.
Or VGA.
Motion carries. The minutes are approved. Item number 3 and the main item before us this evening is a public hearing and action on consideration of a request for approval of an amendment to the special use permit, which the Plan Commission and the City Council approved at the Oak Knoll Woodland subdivision in 2015. The matter is, the petition is to allow the earthen berm constructed on the site to remain as built at a height higher than the height reflected on the approved development plans. The berm is located in the southeast corner of the Oak Knoll Woodlands subdivision, west of the railroad tracks and east of Oak Knoll Drive and north of Abington Cams Drive. So we have some special procedures this evening that we have to consider. What happened here is the petitioner petitioned to have the special use permit amended. There is objection to the petition, and that the objectors are basically asked the city for another or third continuation of the matter. So the first step that we have to go through here this evening is consideration of the request we got a petition, we got an objection on the basis of wanting a continuation. What's first before us this evening is whether or not we are going to continue the matter, or if we decide not to continue the matter, then we will go through a special process in terms of amended procedures for the hearing and hearing from objectors, hearing from the petitioner, and so forth. So at this time, I would like to, and we have with us the city attorney, Mr. Pickrell is here to guide us to make sure that we have due process applied to both sides on this issue before us. So the 5 steps that we'll go through in this first phase to decide whether or not the matter will be continued or not, whether or not we're going to take up the petition are as follows. The first step will be the presentation of the objector's request to continue the commission deliberation of the petition. In that, as I understand it, petitioner has, prior to this meeting, not agreed to continuance. Typically in a procedure like this, if one party asks for continuation and the other, which has happened now twice, where the petitioner and the objector agreed to a continuation, at least as far as I know at the moment, petitioner did not agree to the continuation. And the city basically has fulfilled, as I understand it, its responsibilities for allowing reasonable continuances. The second step in our process will be a response by the city attorney in terms of the process to be followed in this first phase. The third item we will consider is a response by the petitioner on the matter of continuance. And then fourth, the commissioners will discuss the matter based on what we heard in this first phase this evening. And then the commission will decide the question of whether or not to continue the matter or not continue the matter, or anything that might be a combination of those two. So, Mr. City Attorney, is there anything else you would like to add?
No, Mr. Chairman.
Okay, thank you. So I will then call upon a representative of the objectors to present to the commission his position on the continuation.
Thank you, Chairman Lay, and good evening, Commissioners. I appreciate the opportunity. My name is Mark Stang. I'm an attorney, and I'll identify them later, but I represent 7 residents of Lake Forest who are all neighbors of each other. Their 4 homes are adjacent to each other, and they all live on Gavin Court. So later I'll be referring to them as the Gavin Court neighbors. They have been living with...
Excuse me, Mr. Stang.
Yes, sir.
I have something else. I would like to ask the commission whether anybody, any member of the commission has had any ex-parte contacts or any conflicts of interest on this matter before us tonight.
None.
Thank you very much. I'm sorry, Mr. Stang. Please continue.
Okay. The Gavin Court neighbors have been living with this berm and its consequences that I won't address on this motion for the last 2 years.
Excuse me.
Yes.
Excuse me. I've got to do one more thing here.
Okay, certainly.
Anybody who wishes to address the commission this evening, please stand. I want to swear you in. Okay? Okay. Please raise your right hand. Do you solemnly declare and affirm that the testimony you are about to give is true and correct to the best of your knowledge? I do. Thank you. I'm sorry, Mr. Stang.
Thank you. They've been living with this berm for more than 2 years and the consequences that it's had for their well-being and for their property. So I assure you that no one is more anxious than they to bring this to a final resolution. But it's also important that the commission, in deciding this issue, if it does decide it tonight or takes evidence tonight, completes its proceeding, have the benefit of accurate data, to the extent there's going to be data, and expert analysis, and that they receive expert opinions from both sides, from Rialto, and I understand Mr. Swanson has an interest in another entity that I guess is combined with Rialto, and from the Gavin Court neighbors. At the time we requested the first continuance and the second one, there was something we didn't know, but we found out as we tried to enlist experts and review experts' credentials and get their views on an informal consultant basis. What we found out before we asked for this most recent continuance is that this sound testing cannot be done in the winter effectively unless there's no snow on the ground. Snow somehow greatly affects the ability to monitor or actually monitor sound waves coming from the trains as affected by the berm. The other problem that's been more recent is the monitoring equipment, we were told, because we were trying to get tests done, will not operate in under 10-degree weather. And we've had some recent spate of under 10-degree weather. Finally, one expert that we lined up, Dr. Thunder, at the last minute informed Kim Reich that he could not assist us because he was going to be interpreting a noise study that had been done by Rialto, interpreting it to the city. And that was learned a matter of less than a week ago. So we're in a situation where until the weather definitively clears and the snow melts, we can't do any noise testing. We think it's essential not only because this is in the nature of an adversary proceeding, not between me and you, but between Rialto and these neighbors. Incidentally, Rialto's never spoken to these neighbors, not once, never reached out to them. So when they talk about all the good things they did in their cover letter to Chairman Lay, that's something that if we do proceed is going to have to be cross-examined about. It's not just a matter of having witness experts on both sides. We believe there are flaws in the work that was done by Wisjani. They are indeed a reputable engineering firm, but not everyone does everything right or up to snuff every minute of the day at all times. They conducted monitoring for only 2 hours. They only took sounds or recorded sounds or vibrations and waves off of 2 freight trains. And those freight trains are not really described in their report. We don't believe that's sufficient. It's no more sufficient than if a sound engineer was called upon by a municipality in the O'Hare flight path to measure for aircraft noise, to only do it for 2 hours, and then only record a 727 and a Learjet, and no 747s or other aircraft. So we don't believe, as good as they are as an engineering firm, you know, they say garbage in, garbage out. If they have insufficient data, which we believe to be the case, and we have been told by experts with whom we've consulted is the case, then you cannot rely upon their opinions. The second major problem with their report is their monitoring devices, whatever they were, according to their own report, were set up in close proximity to the berm. One at the middle of the berm, one at the north edge of the berm, the other one at the south edge of the berm. Monitoring devices should have been set up hundreds of feet away from the berm in order to assure an accurate measurement of waves coming from the berm and waves coming from a train that are in no way influenced or affected by the berm. That protocol was never established. If we are able to use experts by next April, we will establish that protocol and make sure that you have the benefit of accurate data and analysis before you make a decision. If the continuance is denied, then we'll deal with it. We'll deal with it tonight, I suppose, but it'll only be their expert against no expert. And this is not a situation of the Gavencourt neighbors making in terms of being kind of jammed up to get an expert now. The Rialto knew as of the summer of 2016 that it had a very big berm on its property, even if it tries to lay the blame on the grading contractor, that he showed too much initiative and tripled the size of the volume of the berm and quadruple its height. They went a year and a half before petitioning this commission, almost a year and a half, I should say, for basically for approval, for their as-built drawings to be approved. That could and should have been done if they were truly cognizant of their mistake, and it's a negligent mistake at best, and it might be worse. It's a negligent mistake. They should have taken action within the very next month to come before the city and acknowledge their mistake, and not wait for these citizens to have to discover it and find it out and bring it to the city's attention. So, they wait a year and a half, they notice up or set their first hearing for November, late fall, and now we're in a pickle because of winter, making it impossible for us to conduct effective sound testing. So for all those reasons, and not because we're trying to delay, Gavencourt neighbors want a resolution. They don't want to have to live with this for another summer. We ask you to continue this matter until April. Thank you for your consideration.
Thank you, Mr. Stang. Bob?
Yes. With regards to what Mr. Stang said, there's two issues this commission has to consider when considering the motion to continue. First, what is legally required and what is advisable. So I'll start with what is the minimum legal requirements. The minimum legal requirement here is that the objecting neighbors be provided with due process. And due process simply entitles them to notice and an opportunity to be heard. They've received notice and they're here now. This is their opportunity to be heard. So in terms of have we met the minimum legal threshold to consider this evening? Yes, we have. The city also, in its code, first, the neighbors also are not the only entity with rights in this situation. Rialto also has the right, pursuant to city code, to have their petition heard within 60 days of it being made. If this continuance were to be granted, we would be in exceedance of that date. Now, there is a way around that. If Rialto were to agree to an extension, then that's fine. Then the city code issue would be addressed. However, in terms of due process and whether they've been afforded sufficient opportunity, we've met that threshold. Mr. Stang also referred to their inability to conduct adequate sound testing based on two reasons. First, apparently you can't take adequate sound testing when there's snow on the ground or when it dips below 10 degrees. Mr. Stang had previously advised me of this, so I took the liberty of checking the National Centers for Environmental Information. And we provided Mr. Stang with the city provided Mr. Stang with the Wisjani report on noise on November 15th. And there wasn't any snow on the ground at all until December 12th, when there was 2 inches, when in the next 2 days later it melted. And then again on December 25th, there was 1.4 inches of snow on the ground, and that's when we all know the cold snap hit. And so effectively, the Gavencourt neighbors had 5 weeks, and over the course of 2 continuances, to conduct this testing, and did not unimpeded by snow. Additionally, the 10-degree weather did not appear. Its first appearance was on December 25th, Christmas Day, got down to 3 degrees. So again, that was about 5 weeks after we provided them with our information, with the Wisjani report. And so in terms of their opportunity to conduct adequate testing, they had 5 weeks to do so. Now, moving on to whether it is advisable for the commission to continue or not. At the end of this, the commission can grant this motion to continue right now, and it can grant it at the end of the hearing this evening. There's going to be one of 3 options is going to happen. Either the petition is going to be granted, it'll be denied, or there'll be a continuation based on the need for more information of some kind. Now, I understand that there's, Mr. Stang says he wants to develop an additional expert report relating to sound and also possibly vibrations. That has not been developed. Rightly or wrongly, it hasn't been developed, and we were without its benefit. But we are also constrained by the city code, which requires that we continue this that we hear this petition within 60 days. It is up to Rialto at this point whether or not they want to proceed with the hearing this evening, knowing that the prospect is at the very end there could just be a continuance because we need more information on these subjects, or not. So what I would suggest, and perhaps the chairperson can entertain a question to Rialto, is knowing that this may be continued for lack of information, does Rialto want to proceed? And so I would suggest that question be asked.
Very good. That then leads us to call upon the petitioner. Mr. Swanson?
Good evening, Mr. Chairman, members of the Plan Commission. For the record, my name is Rick Swanson. I'm a partner, as was originally pointed out, in this project. And I also am a Lake Forest resident. I've been listening to the testimony, and I've been listening to the comments from the city attorney and from the commission. And candidly, we're prepared. We've got people coming in from out of town. We've got our expert witnesses here to back up the information that we've provided. I think we've been more than patient in not just one continuance, but 2 continuances. And finally, as the city attorney pointed out, there's been more than enough time for them to prepare and do whatever studies they need to do. I've been advised, by the way, that you can conduct studies in the wintertime, but I'll let our expert witness make that testimony. Having said all of that, having said that we are prepared to do our presentation tonight, there's no point in us doing a presentation if it's the opinion of this board that, in fact, the neighbors should be given additional time to conduct their study. I'm not going to present my case tonight until they're prepared to present theirs. All I've heard their attorney say is that They've known about this for 2 years, and in the 2 years, they haven't done anything except complain about it. They haven't done anything about having their own expert witnesses. And in that time, we've taken the time to work proactively with the city to address alleged drainage issues that were non-issues for us. And we built that berm according to engineering standards. We're prepared to make our case tonight, but we're not going to make our case until they're ready to make their case. If it's the board's position that, and I respect your position if you decide to do this, but if at the end of this meeting you look at each other and say, well, let's give the opposing side a chance to review it, I'm saying to you tonight, I'd rather you have that discussion now, and if you decide to postpone this because you believe that the other side should have an opportunity to prepare their evidence, whatever evidence that might be, we would prefer to do our presentation and present our evidence when they're ready. On the other hand, I want to make it very clear, ladies and gentlemen, that we are prepared tonight to make our argument. I've got my presentation, I've got my experts here tonight. But we also respect there's a process, and we want to do what's best for the city, and we want to have every opportunity to present the facts and let the facts decide how this should proceed.
Okay, so I'm not, I hear an either or response from you, Mr. Swanson, on whether or not you would prefer it be continued or hear it tonight. I mean, you've qualified hearing it tonight.
I have, sir, yes, but I qualify that. I guess what I'm trying to say to you is I heard the city attorney say you have the option of deciding at the end of the meeting whether you want to continue this. We would rather, this is, from my perspective, I may be blunt, this is a one-meeting issue. If we can't make our arguments in one meeting and this panel can't make that decision in one meeting, then there's something seriously wrong. On the other hand, I do respect that this commission should have every opportunity to look at both sides. What I don't want to do is I don't want to present our evidence and then 3 months later have the opposing side come back with, have the opportunity to have it. To me, it's an unfair advantage, to tell you the truth.
I'm now clear on your position.
Thank you.
Mr. Attorney, do you have any comments?
No comments.
Okay, very good. Then I think let's have some discussion among the commissioners on the matter. Mr. City Attorney, is it possible for us, in addition to talking about this with ourselves, can we ask questions of the objector and the petitioner?
Yes, you may.
Okay, as part of that process. Perhaps we should do that first. Does anybody have any questions of either petitioner or objector?
I have a question for Dr. Thunder.
Go ahead. He's in effect city staff. Go ahead.
Right. Good to see you again. Good to see you. So we've heard from both sides that you can or you cannot conduct testing in cold weather with snow on the ground. I'd like to have your opinion on that.
I don't like to do it with snow, but you can certainly do it. It depends on the considerations. If you're looking at the snow between the berm and the residence, that's a constant factor. We're not measuring the noise of the trains. You're trying to isolate the effect, so it's a relative effect. That's why there are multiple measurement locations there. If you're talking about the effect of the snow on the berm itself, that adds some absorption to it. That would affect it. But if there's already vegetation on that berm, the snow's not going to add that much more to it. Again, it's a relative type of a effect. When temperatures drop down low, equipment will still operate unless you're working with obsolete equipment. In the old days, when we're working with reel-to-reel tape recorders and a lot of mechanisms and stuff like that, that would be a problem. In modern times, we work with digital electronics that has no moving parts, so the only thing that's affected is the battery. So what you're looking at is just a shorter battery life. So if you have a monitor out there that you expect to operate for 10 hours, in that kind of cold, it may only operate for an hour or two. But the data that you get will still be good if it's calibrated before and after.
So the cold temperatures changing the density of the air doesn't really have any effect?
Well, it does if you're looking at an absolute issue, but we're not looking at absolutes here. We're looking at relative. Does the berm change the levels? And so whatever affects position 1 is going to affect position 2 and position 3 as well. So it's a relative aspect that we're looking at here, not the absolute. In other words, we're not trying to say what level of noise is there. We're trying to say what increase possibly is the level of noise as a result of the berm.
Thank you.
Further questions?
Dr. Thunder, would you please address Mr. Stang's comments about the 2-hour time frame for the testing and also the fact that the location sites for the measuring unit were near the berm as opposed to near the homes?
May I intervene for a moment?
Yeah.
I'm sorry. Let me qualify what I'd said earlier. We can ask questions. I think that in order to be to fairness to the Gavencourt neighbors, if we get too far into asking about the substance and merit of it, we are perhaps interfering with the presentation they would like to give.
Okay.
And so I understand the motive of what you're asking, but if we try to limit the scope more to the whether you're desirous of an additional expert or something.
But if I could, it would be helpful for the petitioner to know, I mean, Mr. Thunder's going to review this, and so if they're going to come back to us at a later date, I would not want to then tell them they need to reposition the sensors. So shouldn't they know that?
They should. My point is simply that if you know, my concern was that this was going to slowly become a de facto
Understand.
hearing
Yeah.
before the hearing itself. So that's my concern.
Yeah, I saw that as a discrete issue, much like
Okay.
the one Commissioner Pickus raised, but I mean, do we want to have an answer to that?
What's that?
To that question, as to whether or not the locations are sufficiently distant from one another?
Well, or
Can
should
we
we
just-
address the major question about whether we should be continuing this request tonight or allowing the objector's request for a continuance?
Okay, can I ask one question to Mr. Swanson? All right, thank you, Mr. Thunder, or Dr. Thunder. On what date did you first become aware that the berm exceeded the specifications previously approved by this commission?
We didn't become aware of it until staff brought it to our attention as a result of comments from the Gavencourt neighbors. We just didn't realize it. Normally, something like this is something you pick up on as-built.
Okay, so when was that?
I believe it was actually early summer of this year. I can't give you a precise date, but
17,
June, July of
2017?
of 2017, yes, sir. And it was staff that contacted us. It's common for staff to contact us on various issues. And our initial reaction, candidly, was then we'll put it back to the size that it needs to be. And then we found out that the staff reported to us that there were alleged complaints. There were complaints about alleged damage as a result of drainage. In other words, we affected their drainage, and that there were acoustical and vibrational issues. Well, the last thing we wanted to do, candidly, was change what was there, because if you're making an accusation, we first wanted to determine whether this was in fact the case. So we hired our own consultants. We met with city staff. Our consultants met with city staff. We determined very quickly that the issue on the drainage was poor maintenance of their own pond on Gavencourt, and a combination of the fact that the water that drained from them to Metra's property and through and under the tracks.
Yeah, that's all in the reports, and I
Right,
don't want to
okay,
get
so
into the
I-
substance too
all
much.
right, so I won't
can you
regurgitate
give us a date, Kathy, as to when that was that they were first contacted? June, before the July 4th holiday?
I know I was aware, at least by April or May of 2016.
Okay, and then that led to...
I don't know, I can't speak to when our on-site engineering inspectors might have first mentioned it.
Okay, fair enough.
And
Thank
in
you.
fairness to staff, frankly, it could have easily been spring or summer, but it was definitely 2017.
Great, thank you.
17 or 16, Kathy?
I'm sorry, 16.
Mr. Swanson said 17.
I personally was aware in April or May of 2016.
Okay, well,
Okay.
whenever staff let us know, we knew.
Okay. What's the sense, I'm going to ask, I'm going to go one by one in terms of the commissioner to see what the sense is of this body as to whether or not we should continue the matter or just deny the petition here this evening.
Let's start.
Yeah.
So the packet includes an explanation from Swanson Development as to why the site was developed with this non-conforming berm by one of its subcontractors, and I found that helpful, but it's certainly not determinative. I wasn't on the commission at the time this petition was heard, but I was honestly surprised to see that this petition involves a developer that we regularly appears here and enjoys an excellent reputation in our community. As for the due process arguments raised by the objectors, the notice provided and the extensions that were granted for the past 2 meetings were proper, and I think fully accommodated their position. I would note that the petitioner agreed, as we've said, to both of those previous requests for a continuance. And the notice for this meeting was likewise handled properly, so I just don't think there's a support for a due process argument. To the contrary, I think the city has fully accommodated the interests of all the parties, and as Mr. Swanson kind of alluded to, the city even lobbied Metra to help resolve a drainage dispute. So I think it would be hard-pressed to say that there's some kind of due process issue here. Now, if we deny the petition or the motion for a continuance, I do think then, obviously we're going to be tasked to determine whether or not there are off-site adverse impacts related to the drainage, the sound, the vibration. Under the ordinance, the as-built special use, we have to determine if it's detrimental to public health, safety, comfort, general welfare, whether it's injurious to the use and enjoyment of the neighboring properties, or it diminishes the value of their property among a number of other considerations under the ordinance. So in my view, in viewing petitions like this in the past, it has been very helpful to make determinations about adverse impact by hearing from experts from both sides. We've benefited from the city also having a consultant review, at least as it related to the sound, this petition. And if the neighbors didn't get the report, which depending on when petitioner became aware of this, certainly it was no later than June of 17 by what we've heard, and it took them 4 months to put a report together. I think it's reasonable to expect that neighbors might need a little more time than a developer to put together, to digest technical information and hire an expert and do all of those things. So I don't think it's unreasonable to think that they might need additional time, and there are definitely issues here. Even by Dr. Thunder's review, we're going to be tasked with looking at very technical issues as it relates to the grade. There's no question here that this grade is significantly different, and then we have to make determinations as to sound regarding the deflection, as he phrased it, and then I also think we'll have to make a determination as to whether or not, given the steep slope, which is non-conforming to what the commission previously approved, can sound deadening plant material survive on that slope? And I don't think there's, I think those are issues that the residents should be able to contest. As for vibration, the petitioner's own study demonstrates that there are issues there. The expert speculates that it could be caused by splices or imperfections, but does nothing in the report to demonstrate that there actually are splices. So that's in paragraph 2, or page 2, excuse me, table 3 on page 3, last paragraph of page 2. So, from my view, I'm sorry to go off on findings, but I just think it's important to understand why I think a continuance is proper.
You would support.
Yeah, I think it's undisputed that this berm was knowingly constructed in a way that exceeds the clear direction this commission provided and the city ordinance required. There's a lot of disputed facts about drainage, sound, vibration. Maybe not so much on the drainage, but I think it'd be worth hearing. And, you know, although the objectors have had this petition for 8 weeks, I think it's a generous use of the term proactive to say that the developer found out in spring or summer and waited for the city to bring the issue to them. I don't think that's proactive. So I think it's more than reasonable. If we're going to push it, I would say maybe we only grant an extension till March. That's a 60-day in reference to the reasonable time frame for a hearing. And maybe we just continue this to our March hearing. And if the developer decides to do as Mr. Swanson suggested and make the berm conforming, I would make it a requirement that they notify the city and the objectors so that there's no additional, resources spent on this issue.
I'll go second here. I take a differing point of view than my colleague, Mr. Freeman. If we continue, then we've got the prospects of what I call a model muddle, in which we're going to have information from petitioners, measurements, we've got then differing measurements from the objectors' measurements, and brought back to here. And for me, that's not going to do anything, because if that occurred, we're going to have one key, in my mind, very important bit of information that it's impossible to collect, and that is, what were the measurements pre-construction conditions at those 3 homes? So we're going to be presented with, if we continue, which I think is not a good idea for us to continue tonight, because we'll get the objectors' information, we'll have the petitioners' information, they'll argue about that, and for me, the critical fact is, what were the measurements on site at those homes of the objectors before anything ever started? So in effect, we're going to have 2 pieces of the puzzle, an important one missing. And so we're going to throw up our hands and say inconclusive. I think the way out of this is to deny the petition, do it here and now, do it tonight, and have the dirt removed, end of process. That's my thought for the commission's consideration. I may be missing something here, but I don't see anything gained by continuing this matter. Let's not continue, and let's reject the petition. You're next.
Well, can I just say, we should then at least allow petitioner hearing and cross-examination and all of that before we
No.
get to that
No.
decision.
I disagree.
Okay.
I see the issues for both the petitioner and the Gavin Court neighbors. The petitioner did hire a reputable firm. We do have the report. The report was given to the Gavin Court neighbors pretty soon thereafter, November 15th. So there was ample time to gather an expert. And Dr. Thunder was just hired, I think, by the city quite recently, so I'm a little surprised that you would wait until a week before the scheduled hearing to go out and hire somebody. I am very glad to see that the drainage issues had been brought to the fore here, and the city has helped the Gavin Court neighbors resolve that issue. I have some concern for the petitioner in that he has brought a number of experts here tonight. And if this is delayed until March, when, as the chairman points out, some remediation could be done in the meantime, that's an important part of the spring selling season, and it seems to put the developer at a disadvantage too. So I guess I'm on the fence.
Yeah, my initial thought was I was inclined to continue it for, giving the petitioners, a little bit more time to get some sound experts involved. But after hearing Commissioner Lay's arguments we're going to have dueling consultants feed us all this information, it does occur to me that we might not be able to fully solve this issue. And it even goes back to the original berm. How do we know that that berm, if it would have been built to code, wasn't going to affect the neighbors in some sort of manner? As part of all developments do, there's always going to be some impact here or there. And what is the limit of the noise that is going to hit those neighbors? What's the study? What's that fine point? So I'm a little bit on the fence. I think if I were to consider continuing it, I don't believe till March is really, or to April is really fair to the developer. That's a long time to wait and not be able to move forward with your project and perhaps, mitigate, maybe they'd want to mitigate the berm in the meantime. So, and I guess one question is I don't know why they didn't just go ahead and mitigate the beam right away. It's is there a reason, for their development that they wanted this berm higher and thus kept it? Because it seems to me the simplest thing for them possibly would be just to reduce the size of the berm, and then this whole issue potentially goes away.
I'm going to echo a lot of what Commissioner Freeman said, in that I don't think there's a due process issue here. I think that's been served. But I do think, and Mr. Swanson even said it, that in the interest of fairness, the other side should have an opportunity to present their case. I think we owe that to them. If Mr. Swanson wants to continue with this, I think we owe him, the other side to present their case. I think 60 days is a reasonable time frame, so I would be inclined to grant the continuance on a 60-day basis.
So to our March meeting.
Yes.
Okay. Mr. City Attorney, do you have any comments on our deliberations?
If the sense of the commission is that you're inclined to continue, I would also want to check again with Mr. Swanson to see. There was a bit of a if this then that comment. We would need to do so with his agreement. It seems as though that he had implied before. I just would like to clarify now at this point if this information has led you to acquiesce to a continuance.
I think what I'm hearing is that this panel is inclined to postpone or continue this and give the opposing side an opportunity to prepare their argument. If that's the case, my only argument tonight, ladies and gentlemen, is that we don't want to make our case and then have it continued. If it's your decision to continue it, then we'd rather have that discussion now. But we do want to have an opportunity to make our argument, and we're prepared to react to whatever the decision of this board is.
Just to put a fine point on this, so if I'm understanding you correctly, you're saying that if the board feels though that there's more information needed and it's inclined to, and the commission's inclined to want to continue it, would you agree to such a continuance?
If it's to March, if it starts to leak into April and May, I mean, clearly we want to react to this and do what we have to do. The only caveat I would add to this is, the point was made by a couple of members, and I appreciate that. We've already been delayed 2 years. By no one here on this panel was the cause of that, nor was anybody with the city. We've already been delayed. There's been a hardship already created for us. We've got buyers and we've got houses that we want to start. We're prepared to do whatever it is we have to do, whether it's take the berm down. If that's what this is decided that we need to do, then we'll do that. If we determine after all of this analysis that it's best to leave it as is, it doesn't really matter from a construction perspective. What we would respectfully ask this board to consider, and for that matter, staff to consider, is the ability to at least get permits and allow us to move forward. It's not going to change the shape, location of any of the homes or the lots. It's only going to be our either taking 700 trucks through the neighborhood over the next two or 3 months or not. It's that simple. So we just don't want to have the whole process delayed and have an unintended consequence of being basically unfairly delayed during a very good season, as Ms. Kerr pointed out. So, and I appreciate that.
Thank you, Mr. Swanson.
Thank you.
Mr. Swanson, Mr. Swanson, one more moment, please. I'm sorry, and I just want to
Did I answer your question yet, or
No, you came real close for a second. there.
Okay,
And,
good.
I just want to say, if the board's inclination is that they want more information, and I believe you indicated that that's what you believe it wants, would you acquiesce to a continuance?
I heard him say until March, but not beyond.
Until March, but no longer?
The answer is yes to March. I thought March was more than reasonable.
That's fine. I just wanted
Yeah,
clarity for the
that's
record,
fine.
sir. Thank you.
Okay.
So then I don't think a motion is necessary.
Well,
Well,
I'm
we
going to
don't-
make a motion. I'm going to make a motion that we vote to not continue the matter. And then if that passes, then I would then entertain a motion or make it myself to deny the petition.
Excuse me, Mr. Chairman. We were already considering a motion to continue, so we would need procedurally a resolution on the pending motion before consideration of an additional motion not to, I believe, phrase in the
Well,
negative.
and I
Are you
would,
sure I didn't hear anybody make that motion, Mr.?
I'm sorry, I thought that's what that was what Mr. Stang.
may I ask a question?
Sure.
Can we ask the objectors if they would likewise agree to a continuance until March, and then aren't we done?
Yes, you can ask them. The motion has been presented. It has to be considered and voted upon by this commission.
Okay.
So
So you have a motion. I think I didn't make a
Yeah,
motion. I
it's a test-
suggested
it's a
one.
test motion.
I suggested one.
Just to see where the votes are. That's
Fair
all it
enough.
is. If my motion succeed, then that's one thing. If my motion fails, then we'll get into the dates and all that other sort
So
of.
since it's your motion, I don't mean to take your job, but then do we have a second on a motion to not continue the hearing?
Second.
It's been moved and seconded that we.
Discussion? Oh, sorry, go ahead.
Yeah, now time for discussion. Any further discussion on the motion?
I think to deny it when the petitioners has already agreed to it, I worry that we're going a little far afield of our responsibilities. If the parties are okay with this, I'm certainly okay with it.
But I predict what's going to happen. We'll continue to March 30, the March meeting. And then we'll be in this model, without the information as to what the pre-construction conditions were there as far as noise in terms of vibrations.
Right.
None of that, it's impossible unless we take the berm completely down. And I don't think anybody on this commission or else is going to require that in order to get the true measurement, the third leg of a three-legged stool. So
Right, but-
I predict that there'll be continuations well into the summer.
So I certainly wouldn't want to do that, and I'm mindful of the cost to the petitioner on this already. What I would say is, based on what the consultant for the city has told us, it's not a absolute, relative number before, after. That what's relevant here is the sound or the vibrations or the drainage different in the area of this berm than it is in other areas? So it's a relativity. It's not a certainty before and after, as I see it. So that's what we've been told. I'm not an expert, but I find it helpful to rely on the experts. And if the city's consultant is telling me that that's not necessary, and the developer has an option. I mean, this commission has already approved a berm. That berm can be put in at any time and they can move forward. So they have an option. I don't think we should, I think we should rely on what we've been told by the expert here, which is that it's a relativity, it's not an absolute. But that's my view.
Okay, all those in favor of the motion to not continue them, all those in favor say aye? Or those in favor of the motion to not continue, say aye.
Aye.
Aye. Opposed, no?
No.
No.
Okay, I have 3 votes against and 2 in favor, so the motion fails. Okay? So now a motion,
I'll make a motion that we continue this petition until the March meeting.
Second.
okay,
The only comment I would make is I don't know that it's necessary procedurally, since the parties have already agreed, but if that's, just so that's for the record.
Yeah, it would be clear for the record if
Okay.
we have to take action on that.
All right,
sure.
that's all the comment I have then.
Yeah,
We vote?
I would just suggest to objectors that if this is continued, that your expert and the expert for petitioner somehow not make this an inconclusive matter when you come back. Because I suspect that's what we're going to get.
Well, I think staff can guide both parties on, and you may be working with Dr. Thunder to prescribe methods and means and methods for doing the testing so that they're somewhat the same, so that the results can speak for themselves.
I don't know that much about this, probably enough to be dangerous here, but how do you come up with a proxy for what the noise and the vibrations were without before that berm was ever constructed even an inch higher than the
Well, again, as Commissioner Freeman has noted, that doesn't really matter because a berm has already been approved. So really the matter is whether it's 17 feet high or 29 feet high. That's the issue.
Good luck, consultants, on that one. Good luck. Okay, all those in favor of the motion to continue the matter, say aye. Opposed, no. Clerk will call the roll.
Aye.
Aye.
No.
Oh,
Do we need
Clerk
a
call the
roll?
roll.
We can do a voice vote.
Yeah, no.
Commissioner Freeman?
I'd like a roll call.
Could you state that again? Because it seemed to me, I was a little confused by the motion.
The motion is to continue the matter
Till March.
to March 30, the March.
Okay, so the date being March 30, that's what, okay.
March 15,
March
just to be
15.
clear.
The March
The
meeting.
March meeting.
Yes, okay, thank you.
So the motion before you is to continue the request for an amendment to the special use permit to the March meeting of the Plan Commission.
Okay.
And I'll call the roll. Commissioner Freeman?
Aye.
Chairman Lay?
No.
Commissioner Care?
Aye.
Commissioner Ruggles?
Aye.
Commissioner Pickett?
Aye.
4 ayes, 1 nay, the motion passes.
Okay. So all of the presentations and cross-examinations will be delayed until our meeting date in March is March 15th, is it not?
It is
Thursday.
actually the next.
It's going to require another motion.
Yeah, I'm sorry.
That's right.
Thank you. Thank you.
Work that in about 3 minutes.
Thank you very much. Okay. Okay. So that matter has been dispensed with.
Yes.
Then the next item is opportunity for the public to address the Plan Commission on matters not on the agenda. Seeing nobody interested, number 5, additional information from staff. Kathy?
So you do have an amended meeting schedule before you. You did approve a meeting schedule at your last meeting. We did hear of some conflicts. So the change that is reflected on this proposed schedule is that in March and in November, the meetings would be on Thursday of your regular week. So on March 15th and on November 15th. So again, not on your regular Wednesdays, the second week of the month, but the Thursday. So if you are okay with this, then it would be appropriate for someone to make a motion and to have a vote on that.
I move we approve the amended schedule as submitted by staff.
Second.
Okay, all those in favor indicate by saying aye.
Aye.
Opposed, no. Motion carries. We have an amended meeting schedule. Okay. Okay, a motion to adjourn is in order.
So moved.
Second.
Moved and seconded. All those in favor of adjournment indicate by saying aye.
Aye.
Opposed, no. Motion carries 5-0. Thank you all.
Thank you.